Good morning. A few moments ago I had the opportunity to speak to Sam Stozer and to congratulate her on her remarkable win. She is a woman who is heading for a celebration, and I assured her that the whole Australian nation would be celebrating with her. This is a remarkable achievement. Sam is the first woman to win a Grand Slam title since Yvonne Goolagong in 1980. She's the first to win one in the US since Margaret Court in 1973. So, a great achievement. I did have to say to her that I was unable to watch all of the match. I was having the scores yelled out to me this morning, but it reached a point where we had some other work to do, so I wasn't able to watch it all. But I know around the nation there would have been millions of Australians transfixed and watching it point by point. So congratulations to Sam Stozer. I'm here with the Minister for Immigration and Citizenship to deal with another matter, and that is the government's response to the High Court case. The government has been working and considering its response for a period of time. As is well known, a number of months ago, the government announced that we were intending to seek an arrangement with Malaysia to transfer asylum seekers to Malaysia. We determined that that was the best course of action to smash the people smugglers' business model. We determined it was the best course of action to make sure that we sent the maximum message of deterrence and stopped people getting on leaky boats where they could lose their lives, men, women and children. And tragically, we've seen men, women and children lose their lives on our shoreline. We determined to pursue the arrangement with Malaysia because we also believed that it opened up a good dialogue within our region, that it was based on a regional process which came to fruition in Bali and enabled us to work through regional solutions. And finally, we determined it was the best approach because it would enable our country to take 4,000 refugees from Malaysia, people who have waited often for many years to get a chance at a new life and a new start in a country like Australia. Malaysia offered the best answer to the issue of asylum seekers and people smuggling then. It offers the best answer now. And so we are determined to pursue bringing to life the arrangement that we have made with Malaysia. So today I can announce that the government has determined that it will bring to the Parliament amendments to the Migration Act that enable the government to make the decisions necessary to have asylum seekers transferred and processed in third countries. These amendments will be broad in nature. They will enable the government of the day to design and implement its best solution. The best solution from our point of view is the arrangement with Malaysia with a complementary centre in PNG. But the amendments we will bring to the Parliament will be broad amendments which will restore to executive government the ability to make the arrangements that it sees fit for the transfer and processing of asylum seekers in third countries. There's been a lot of discussion about what works when it comes to deterring boats, and I want to talk for a moment about what works. There have been a lot of claims in the public domain that having a processing centre on Nauru would work. The advice to government consistently has been crystal clear that having a processing centre on Nauru would not have the deterrence effect that we seek. The Howard government did process asylum seekers in PNG and on Nauru, and the outcome of that arrangement was that around 95% of those who were resettled, who had been processed on Nauru, were resettled in Australia. People smugglers have got that message, and they now understand that a processing centre on Nauru is really just like another Christmas Island. It's a place where you are processed, but if your claim is accepted, then you will be settled in Australia. What that means is the people smugglers are able to say to people that going to Nauru is the same as getting a ticket to Australia. Well, we've been determined to send a stronger message of deterrence than that, which is why we are determined to implement the arrangement with Malaysia. The arrangement with Malaysia means that people will not see their claims processed in Australia. It's very different from the circumstances with Nauru. Now, I understand that views vary across the Parliament on these questions, and the opposition, despite expert advice to the contrary, continues to pursue Nauru as its option. That is as it may be. And if there is a future Liberal government that has that as a perspective, then under the amendments that we will bring to the Parliament, that future government would be able to enact that plan. But the government, based on expert advice, does not agree that Nauru is a deterrent. Our advice couldn't be clearer, and that's why Malaysia, when we announced it, was the best option for smashing the people smugglers' business model, and it remains the best option today. In terms of the parliamentary proceedings, I do note that the Leader of the Opposition said last Monday, and I quote his words, "I think that our country should have the best border protection policy that the government of the day thinks that it needs, and I'm prepared to work constructively to give the government, to restore to the government, the option of a third country offshore processing, which it says the High Court and the Solicitor General has denied to it." Well, on these words, Mr Abbott and I are in agreement, and it is amendments to the Parliament. The amendments that will be brought to the Parliament will reflect those words. It will put executive government in the position to make the decision that it sees fit. And our decision is that Malaysia says you will not get to Australia. Nauru says you'll get a ticket to Australia. That's why we are determined to implement our arrangement with Malaysia. I'll turn now to the Minister for some comments and then we'll take questions.
Thank you very much, Prime Minister. As you know, in 2001, the Parliament passed legislation to allow for offshore processing. This was legislation supported by both sides of the Parliament at that time. The clear understanding of both sides of the Parliament until the High Court decision was that this enabled the Minister for Immigration of the day to nominate a country for third-party processing where the Minister had made the determination that the protections in place were appropriate. Indeed, under that existing legislation, a declaration was made for Nauru and Papua New Guinea by Minister Ruddock, which were thought until the High Court decision to still be valid and still be in effect. The High Court not only ruled invalid the declaration of Malaysia, but the legal consensus is that the reasoning of the High Court also meant that Minister Ruddock's declarations of Nauru and Papua New Guinea should also be held to be invalid. The High Court found not only was the Minister's decision reviewable, but there are a range of circumstances which should be taken into account, going to the legal enforceability of protections, work rights, health and education, which in the views of many eminent legal commentators have meant that New Zealand would be the only country in our region in which third country processing could occur. It's been the view not only of the Solicitor General, but of Mr Kennett, Mr Lloyd, Mr Merkel and Mr Escourt, all Senior Counsel or Queen's Counsel, that the High Court's judgment ruled out not only Malaysia but Papua New Guinea and Nauru as well. The legislation that we will introduce into the Parliament will seek to return the Migration Act to the previous understanding of both sides of the Parliament from 2001 to 2011. In relation to unaccompanied minors and children, obviously the High Court made a number of findings there as well. The result of the High Court's finding was that no unaccompanied minor could be removed from Australia without the written agreement of the Minister, and that written agreement was judicially reviewable and it must be established it was in the best interest of the child to be removed. Importantly, our advice is that that ruling applies not only to asylum seekers, but to failed asylum seekers. That is to say, an unaccompanied minor claims protection in Australia. They are found not to be a refugee by the Department. They appeal that to an independent review, found not to be an independent not to be a genuine refugee, goes through the courts and fails, and then if the Australian government took steps to return them as a failed asylum seeker, they would be able to claim under the High Court's ruling that it was not in their best interest and they should not be removed from Australia, and that would be a claim which would be likely to succeed. Now, in our view, that is clearly not sustainable as public policy, and we will also seek to return the law to its previous understanding that the Minister for Immigration of the day has the discretion to deal with these matters as appropriate. Now, of course, we are working very carefully through the proposed legislation. We've been working on options since the High Court decision, but the Cabinet has today approved this way forward. We are testing proposed legislation to ensure that it's as robust as possible. It's being tested not only with the Solicitor General and the Attorney General's Department, but with eminent senior counsel from the private sector to ensure that it is robust as it possibly can be. I would envisage that the opposition will be briefed on the proposed legislation in the coming week, and we would move to introduce the legislation into the House of Representatives in the next sitting week.